So let me say something that might make you uncomfortable. If you have minor children and you do not have an estate plan in place, this video is not optional for you. And if you don't have kids yet, this might not be urgent for you. But if you have children under 18, you need to stay with me, because what I'm about to explain is not dramatic, it's not fear-based, it's not sales pressure, it's just reality. And most parents don't understand it until it's too late. First, let's clear up something. So estate planning is not about how much money you have. So I hear this constantly. We don't have enough assets yet. We're still building. We'll do it when we're older. We're healthy. And estate planning is not about wealth. It's about you being in control. And when you have children, it's about one thing: who raises them if you can't? This is what actually happens if you don't have a plan. And let's walk through this slowly. If something happens to you and your spouse, or if you're a single parent and there are no legal documents in place, that you've not legally named a guardian, which means the court gets to decide. A judge who has never met your children decides who raises them. Family members can petition, multiple relatives can fight, temporary custody arrangements can be put in place. In some situations, children can be placed in temporary state care while the court sorts it out. And while all this is happening, your children are grieving, they're confused, they are destabilized, they are surrounded by legal conversations about where they're going to live. And that's not something you want them navigating at the worst moment of their lives. And yet, this is exactly what happens every single year to families who thought they had more time. You know, my sister would obviously take them, but would she? Have you legally named her? Have you named a backup in case she can't? And have you discussed it with her? Have you put it in writing in a legally binding way? Because if the answer is no, it is not automatic. I've seen cases where the one side of the family assumed they were the choice, the other side disagreed, and the conflict turned into litigation, and the children were in the middle. So hope is not a legal strategy. Now here's the second piece most parents misunderstand. Even if you think, well, at least they'd get our money, yes, they would. But at the age of 18, if you only have a will and no trust structure, your child inherits outright at 18 in most states. That's 18. And are they mature 18-year-olds? Maybe. Are they equipped to manage 6 figures, a house, investment accounts, life insurance payouts? Probably not. And here's where parents pause, because suddenly this isn't abstract. Suddenly you're picturing your actual child at 18, and that changes things. And before we keep going to understand estate planning, you know, it's not about death, it's about protection. It's about stability. It's about removing chaos from an already painful situation. And I'll say something slightly controversial. If you have life insurance but no estate plan, you've only done half the job. Life insurance sends money. An estate plan sends direction. And without direction, money creates as many problems as it solves. So here's what you're going to do. Step 1, name that legal guardian. This is the bare minimum. You legally designate the primary guardian, a backup guardian, a temporary emergency guardian. And this is done in a properly drafted will or standalone form, not in handwriting, not in a text message, not in a Google Doc, a legal document. This one decision alone eliminates court guesswork. Step 2, create a trust for minor children. If you leave money to minor children, it should not go to them outright at 18. A properly structured trust allows you to choose who manages the money, set distribution ages such as 25, 30, or 35, or a staggered age. You protect it from creditors. You protect it from poor decisions. You can even include guidance, education preferences, values, intentions. It's not control from beyond the grave. It's leadership. Step 3, plan for incapacity. This is the part most young parents completely ignore, because statistically, you're more likely to become temporarily incapacitated than to die unexpectedly. If you're in a car accident tomorrow and unable to make decisions, who pays your bills? Who manages your business? Who signs tax returns? Who talks to doctors? Without financial and medical powers of attorney in place, your spouse may need court approval to act. It's court approval during a medical crisis. And most people are far more vulnerable during incapacity than death. And yet, this is the most overlooked piece of planning. But we're healthy, and I hear this constantly, and I say this gently, that health is not a guarantee. Age is not a guarantee. Timing is not a guarantee. Planning is not predicting tragedy. It's removing uncertainty, and there is a difference. So let me ask you something honestly. If something happened to you tomorrow, would your children know where they're living, who's in charge, what you wanted, or would everything feel unstable and reactive? Because here's what I see over and over. Parents delay because it feels uncomfortable, but once it's done, they sleep better. There is a calm that comes from knowing it's handled, not because you're expecting something, but because you've removed the unknown. And let me be very clear, estate planning does not have to be complicated. It does not have to be overwhelming. It does not require you to be wealthy. It requires one decision: to stop saying later. That's it. I have young kids, and if I had no estate plan, I would do 3 things this month. I would name my guardians legally, create a simple trust structure, sign financial and medical powers of attorney. Not next year, not when things slow down, and not after vacation, this month. Because once it's in place, you're done. You update it every few years, you adjust when life changes, but the heavy lifting, that's one focused season of action. Because avoiding estate planning doesn't make it less likely you'll need it. It just transfers the burden to your kids, to your spouse, to your parents, to your siblings. You either handle it now or they get to handle it later, under pressure, under stress, under grief. That's the difference. So let me recap. If you have minor children and no estate plan, the court decides guardians. Money may be distributed at 18 outright. Incapacity can trigger court involvement. Family conflict becomes more likely, and everything becomes reactive instead of intentional. But with a plan, guardians are named, your money is protected, authority is clear, stress is reduced, your wishes are honored. Estate planning is an act of love, not fear, not pessimism, it's love. Your next step, if you're watching this and thinking, okay, it's time, start simple. I have an ebook link below called The Living Trust Blueprint. It breaks this down clearly so you know exactly what to ask for when you meet with an attorney. Or if you're ready to move forward, book a consultation with me. But don't close this video and say, I'll think about it, because that's what everyone says before they don't. You don't need to panic. You just need to act. And once it's done, you get to go back to being a parent without the weight of uncertainty hanging over you. That's the goal.